So I thought today's video was going to be about the next lawsuit. Instead, it's about the next lawsuits. The next lawsuits. And in this video, we're going to talk about the new Homey lawsuit out of Utah, and also the next lawsuits in regards to buyer agency agreements and how those also might be an antitrust violation depending upon how you're using them. And as always, we have our notes, which in this particular case is the Inman article about the Homey lawsuit, which originally was broken by Housing Wire. And then after that, we're going to talk about the consumer group behind the Morrell case and how they're viewing the next round of lawsuits. So the Homey lawsuit is very, very interesting because it's one company suing other industry, big real estate. You know the ones. And just for the record, I've been a big, huge fan of Homey for a long time as an innovative business model. I know in the last couple of years they've had some difficult financial times as the markets have changed. But I remember several years ago, 7-8 years ago, I think I actually kind of built a wireframe website that would have accomplished the same thing of Homey here in Massachusetts, but really didn't have the capital to launch that, A, and B, one of the things that makes it successful in Utah, and I think also they operate in Arizona, is that a lot of the houses out there, for instance, are, they have a higher degree of uniformity than we do here in Massachusetts. By the way, I'm here in beautiful Cape Cod in Woods Hole. Got a home inspection going on right here. I'm a little bit early, so I decided to make this video. Sporting my brand new Nantucket sweatshirt, looking a little bit Cape Cod-y in the islands today. Hope you're doing well, enjoying this late summer weather. So the Homey lawsuit basically says that they're targeting the now defunct participation rule, which required agencies to list a broker commission. You'll remember that NAR did away with that back just before the lawsuit. I think they did away with it in October of 2023 as kind of a way like maybe we can head off this whole lawsuit situation. But by the end of October, they lost the lawsuit, right? They are arguing that, quote, if I could use it from their lawsuit, using their control of the MLS, defendants imposed rules nationwide that erected substantial barriers to entry for new competitors, thereby elevating the price of residential brokerage services well above competitive levels. This sounds very familiar to the Sitzer-Burnett case, for instance, and many of the other lawsuits, that not did they actually set prices, but they elevated the price of what those services might be. Specifically, they are targeting express and tacit boycotts. Express and tacit boycotts that, quote, steer buyers away from Homey listings. And I think that this is very, very interesting because it might be an insight to not only Homey's lawsuit, but what might come in the future if agencies start to sue each other. Remember, what was it, about 2 weeks ago, I made a video about this interaction I had on another listing of mine where I got an email that said, and I made a video about this, if you feel there will be a commission, I will show it. But if not, then I will move them in a different direction. Let me know, thanks. Now, I'm not going to credit the real estate agent that wrote me that, but I made a whole video about that, and I said it was 100% wrong. Let me requote, I should say. If you feel there will be a commission, I will show it. But if not, then I will move them in a different direction. I mean, that's just like I'm steering them. Now, when I contacted that, which is illegal, now when I contacted that agent, he said that no, they're self-selecting, which is actually a topic that we're going to mention relative to the second lawsuit, because you really can't have your own clients self-selecting, but we're going to get that in a second. So the major defendants in this Homey lawsuit are Anywhere, Home Services America, Remax, Keller Williams, you know the ones. And they have some text messages to prove that this has been a problem for Homey. I think that they probably have a lot more text messages than, I just had one listing where I offered 0% commission, and I got a couple of these types of messages. What really bugs me the most about this particular email, which again, I'm not going to credit the agent or discredit, he write, I understand the changes going on with the real estate commissions. Well, clearly you don't. The defense here by Home Services of America, in one of the quotes here in this Inman article, was that the top brokerages have had a lot of change over the last 10 years, I think he indicates. And that may or may not be true, but my refutation of that is, did the business model change? Did the business model change? Because your top brokerages might come and go, but if they're all operating on the same business model, then was there really a diversity of choice for consumers? I think the Home Services argument on that case falls flat. Let's talk briefly about the Morrell case. My home inspector's just arrived, but we're going to get to him in a minute because he's early. This is brought to you by the attorneys at Cohen and Milstein. Now, to begin, they haven't filed a lawsuit yet, but it's coming. And yeah, it's coming for sure. They're coordinating with the volunteer-run nonprofit, the Consumer Advocates in American Real Estate, which I think I've covered in prior videos at least once. They're a little passive-aggressive. They say there's all these problems, but they really don't have any solutions in any way, shape, or form. They just continually point out things that are wrong. But having said that, there's a role for that, of course. And Cohen and Milstein, you might remember, is the plaintiff or attorney in the giant Morrell case. So this giant law firm and this tiny little nonprofit are teaming up because this guy that runs it, Doug Miller, has a wealth of knowledge, according to the law firm, about an industry with no formal antitrust or economics background. That's because most of these things are, how do I want to say this? Common sense if you just read the law. And he's targeting the, quote, workarounds to the rule changes. And I want to make it clear that they're not targeting the technological workarounds to the rule changes. They're targeting the paperwork rule changes. Realtor competitors gather as groups to design fee agreements to accomplish this. Quote, this is from Mr. Miller. We believe this is straight out collusion that violates the spirit of the settlement agreement. A direct quote from Inman from Mr. Miller. Quote, form committees composed of competitors who design fee agreements that result in higher buyer brokerage fees are likely to be the target of future litigation. Hey, how you doing? I'll be right with you, all right? Thanks for being early. Hey, I got a business to run. Miller stressed that he's warning the industry about this because it's the last thing he wants to see is more litigation. Well, I don't know about that. I think it's the first thing he wants to see. But aside from that, next page. By now, all realtors know that it is very easy for a buyer agent to work with a buyer when the seller isn't offering any compensation. All they have to do is write it in the offer. Now, they're suggesting a seller credit. You can also just request that the seller pay the buyer broker directly. Either way, I think is fine. They seem to be a little higher on the idea of seller credit, but whether it's a seller credit or a direct payment to the buyer agents, I don't think that makes much of a difference, but they seem to be fans of seller credit. Some agencies are using a checkbox on their buyer agency agreement. And this checkbox is basically asking the buyer to self-steer themselves away from listings that have no compensation offered. And there becomes a big question of whether or not a buyer can actually knowingly consent to that? And yeah, can they really consent to that? If a seller offers nothing, it forces buyers to make the first move to ask for a credit instead. And that leads to competition on buyer brokers' fees. I think this is the money point here. The credit is going to be smaller if buyers negotiate a good deal to their agents. If the listing broker offers mixed amounts to or fixed amounts to all buyer brokers, the benefit of negotiating a buyer rep fee deteriorates. This is what I've been saying all the time. You know, when you're bargaining, let's just say to buy a used car in the driveway, to use that classic example that I've talked to you before, it's listed for $5,000. The guy takes it for a test drive, kicks the tires, and then he says, hey, well, what can I get this car for? The first person who mentions a price first loses, right? Dad always taught you that. Dad was right. The first person who mentions a price loses. It should, if you want to have consumers pay less in buyer agency fees, which is better for consumers, and there's a whole slew of market competition, business opportunities that open up because of that. See Homey, lawsuit number 1 that we talked about in this video, which, and by the way, we should be in the opportunity business, not the real estate. You should be an entrepreneur. If you're thinking about this as an entrepreneur, you've got the right mindset. Whoever mentions the price first loses, and that's what this whole thing is about. By mandating under the participation rule that you had to put in the commission, by mandating that first, which is now defunct, right? Now defunct. But by mandating it first, and now by basically forcing sellers to put something in there, because otherwise you're not going to show them the home, like the email I just got, by forcing them to put it in there, that could be construed as a group boycott and basis of an additional lawsuit, which is basically what Mr. Miller and Cohen and Milstein are talking about in this second lawsuit. So don't put anything in your MLS, obviously, or maybe on your website. I know there's a big company that just announced the other day, hey, we're going to put it on our website. No. Let them be in the dark. Let them negotiate it with their buyers and have it written in the offer. So, hey, you know, you could write in an offer for 1% or 1.5 or 7.5 or whatever it's going to be, but it's negotiated between the buyer and the buyer's agent, and then it's put into the offer. That provides compression on prices because they're forced to have that discussion before they submit the offer. All right, so I'm Jack from Jack Gately Real Estate and the Online Real Estate Academy. It is exactly 8:31. I got to go do this home inspection. Have a great day. Bye-bye.